and waffling for about 5 minutes. He then says that the AG did not do anything. This is standard. Waffle, then criticize the AG. Then he misquotes the AG in order to grab a headline. This is standard. I then get up on a point of order. The honourable member then gets upset and throws a tantrum. And then spends the next 5 minutes thereafter attacking me. And then, sir, he throws in a quote from Shakespeare just to be good. If we actually look at his last series of speeches where this order has obtained, sir, this is exactly the agenda that follows. He threw in the speech on Shakespeare, this time, sir, from Julius Caesar, in reference to the AG. I know of no personal cause to spurn at him, but for the general. Sir, I also want to help to educate him of one of my favorite quotes from Shakespeare that also dealt with the treachery and betrayal of a trusted person. And it talked about life, but you can substitute the word life for anything else, like leader. Life, sir, or leader of the opposition, is but a walking shadow. A poor player that struts his hour upon the stage and then is heard from no more. It's a tale told by an idiot, full of sound and fury, signifying nothing. So, if we quote in Shakespeare, let's trade quotes. I will note yours.
Honourable member for Christchurch. No. The point of order? Is there a point of order?
I don't mind the quote.
No. Is there? You can only raise on your point of order.
Yes.
What is the point of order?
Offensive speech.
I will not. Continue, Honourable member for Christchurch East.
Yes, let him continue.
Continue.
Interesting, sir, that offense was taken where none was intended. I simply traded a quote for a quote. But who the cap fits, let him wear that another quote. Sir, my level of confusion following during the address of the Honourable Leader of the Opposition, sir, was due to the blatant inconsistency in what he's saying. On one hand, he says that the government was cowardly and timid. It didn't go far enough. It did not take the opportunity to go far enough. On the next side of his mouth, he talks about having regard for the right to liberty and the right to freedom, that this may be inconsistent with that right, but still talks about we did not go far enough. So I listened carefully because I was actually waiting to find the points of contention with the actual legislation to then deal with them one by one. After, sir, wandering all over the place to talk about everything under the sun, when the Honourable Leader apparently accidentally collided with the subject matter, then, sir, the only complaint, the only comment about the actual terms of the bill or the clauses in the bill was to say that the part defining section 6.1, circumstances in which bail may be refused, should actually be circumstances in which bail shall be refused. We missed the perfect opportunity to make it mandatory as opposed to permissive. That, sir, if you actually shift out all the irrelevancies, all the tangential discussion, all the fluff, that, sir, was the only constructive comment in relation to the entire piece of legislation. Now, let me help the honourable member, sir, who seems to have forgotten all of his legal training. The reason that the last amendment was struck down by the court was because the court was of the opinion it interfered with the discretion of the court. It gave a mandatory position that the court had to follow, that effectively, as he's talking about the arms of government and separation of power and interference in the police service, effectively, Parliament attempted to fetter the hands of judiciary. Parliament attempted to tell them what they have to do in a particular circumstance. Sir, I contrast that reasoning of the learned Justice Griffith with the contention, the last contention by the Honourable Leader of the Opposition, that we should take it out of the hands of the judges, that this government should be bold enough to make that decision itself and remove it from the hands of the judges. I do not know what court of law in Barbados he practices in. I do not know. I do not know if you read the decision of the court. And perhaps some things you cross principles. Sometimes you look at a principle that everybody is familiar with to explain another principle. The same separation of powers and discretion of the judges, judiciary, and federal judiciary was the whole basis for striking down the mandatory death sentence. The law, the court, all the way to CCJ said, hell, you could order death sentence. The death sentence can be on your book. We're not telling you can't hang. But the legislature cannot tell a court, if you find this, then it has to be that. That went all the way to the CCJ. That is pellucidly clear as law. The reasoning is sound. That was the exact same reasoning that the court used to strike down the other provision. So for the honourable member to come and stand up in here, and grandstand as if spouting some new form of law, as if airing his letters KC before the world. If we did what he was suggesting that we do, we would be back in the exact same position as we were when the court struck it down. Or in the exact same position when they struck down the mandatory death sentence. I sometimes wonder, sir, if the Honourable Leader tastes his words before he says. You know, sometimes you think to say something clever, but if you actually voice it first and listen to it, you realize it sounds stupid, and you backtrack from that. Sir, the Honourable Member spoke about there being nothing revolutionary in this. No change. It ain't add nothing to the last piece of legislation. It will not attract any difference in its application. Sir, I am convinced, no, he didn't read it. I am convinced. The issue, sir, the issue confronting the public on which there was public outcry was the fact that bail was being granted to people who were convicted or who had charges for murder or firearm offenses. That was the public discussion. It was clear. Everybody in Barbados knows it was that. People.
Honourable, please. No, you can't speak from there. You spoke for your time. Please allow the Honourable Member for Christchurch East to speak.
Sir, let me help you. He didn't just speak for a long time, he spoke ad nauseum. And the focus being on the nauseum part. Sir?
You know, Honourable Member, there's a marshal sitting out there who has no work to do, you know. Honourable Member Christchurch, so there's a marshal there who thirsty for work. He's thirsty for work.
Sir,
he's thirsty for work.
The argument and the contention was made that nothing different has changed. All of us in here to a man either heard or identified with the outrage of the Barbadian public in relation to the campus trans killing? Let's pick the common ones. All of us in here, to a man, were in shock and horror when the shooter went into Sheraton Mall and shot at the place, reckless as to who was endangered. All of us in here were in horror when they had the Kadooment there shooting that injured a whole ton of people. And people in Barbados said, I hope that man don't get bail. In each one. We have heard instances of persons being out on bail when they had 2 pending murder charges. Persons being out on bail, sir, with multiple firearm charges. And the public of Barbados with one voice said, and we listened, how can we have faith in the system when somebody on gun charges, somebody on murder charges can go to the court to get bail? We tried to do it in 2019 with the 24 months. That was struck down. Since then, certain things have gotten worse. I admit they've gotten worse. The Honourable Leader of the Opposition said they've gotten worse. We were in discussions about what to do next. How do we deal with this? This came up in cabinet, it engaged the parliamentary group, it engaged the whole of Barbados. The Honourable Leader came in here and said that he is not about pride or vanity. Sir, he missed a word. The word is hubris. It is hubris, sir, to think that we as a government are responding to him to correct a situation that we all know exists in Barbados. This government is doing this to secure the integrity of our systems in Barbados. We are doing this to ensure that our judiciary and our judicial system is respected. We are doing this that when people see heinous crimes being committed, they have comfort that the decision taken in respect to bail is going to be reflective of the public outrage and the public outcry. We are not doing this in relation to a request from the Leader of the Opposition. I might surprise him to know that he does not even come up in our discussions. We had to recognize him in some way when he was on one side of the fence. But from the time he crossed, sir, it solved a problem. We now don't even have to acknowledge him. But let us talk about revolutionary. Let us talk about revolutionary. As it stands now, and this is so the public of Barbados can understand, when a man is charged and he goes into the court, his lawyer will stand up and say some usual things. He will say, he's a good fella, he has a job, he's the sole breadwinner, he's not a flight risk, he got 10 children, he provides for them, and. No evidence is given. No evidence is given. The lawyer will say all of that. The prosecution then gets up and they say, if he's released, he may interfere with witnesses. We had sufficient time to complete the full investigation. The gun has not yet been recovered. Make their arguments, and then everybody sits down, and the judicial officer then makes a pronouncement. Either bail granted with conditions, or bail denied, accused remanded. That's it. That is it. So as it stands now, when we see someone charged and appearing for bail, and the judge, in circumstances when the whole country, everybody is watching, saying, he can't get bail. That man he cannot possibly get bail. No. If that man gets bail, the judicial officer has, at the time of granting bail, to give written reasons for his decision. He has to say why. He now has to explain to all of us, and it's a matter of public record, what informed your decision in granting bail to this person that everybody feels should get locked up. It would be a brave judicial officer that does not exercise his mind judiciously and bear in mind the responses of the public. That is as revolutionary as it gets. Back before the public concern, the public outrage, the whatever, that was not a factor for the court at all. At all. It is now a factor. Another factor. I've been in practice for 27, 28 years. The Honourable Member has been there before me. 40 years. Fine, sir, 40 years. For 40 years, sir.
Listen not to the Honourable Member.
No, sir.
Listen not. Exercise judicial deafness from the Honourable Member.
No, sir, I'm actually silently reciting the Serenity Prayer, sir. I got to the things I can't control, and I'm just like knowing the difference, okay? Sir, in my entire time in law in Barbados, I have never once, not once ever, seen the prosecution attempt to appeal a decision on bail. I don't know if they didn't have a right. I didn't see it in the last piece of legislation, but I know that I have never seen an appeal from a bail application. It is not even common. It is now embedded in this legislation. If, against all the odds, somebody who commits a heinous offense, who is previously known to the court, is granted bail, the outrage doesn't just stop there. The prosecution now has a right to appeal, a right to take it a step further, to let the decision of the judge be reviewed by a higher panel. If that is not revolutionary, I don't know what it is. What is? Sir, it perhaps helps if I actually, the Attorney General did it in his statement, but I'm going to do it now in this context, having explained that. Sir, under circumstances in which bail may be refused, it gives a whole series of things, sir, the normal ones, but then there's this critical one. Where in exceptional circumstances, there's a likelihood that the release of the defendant will not be in the interest of public order or public safety or public security. Now, what does that mean? The other revolutionary thing in this piece of legislation is that it sets out the circumstances in which bail may be refused. Is A, B, C, D, E. Right? Section 6(2). If you had read it, you would know where it was. It sets out, sir, the circumstances in which bail may be refused and itemizes them. But then it goes further. It did something I have not seen before in our legislation. It then sets out the examples under each of those circumstances. So if the one I read before about the public outrage, sir, let's go to that. And for the benefit of the Honourable Member, that's at section 6(7). In considering whether the ground in subsection 2E has been established, the court may, where applicable, take into account the following: whether the nature of the offense or the circumstances under which the offense was committed is likely to induce a sense of shock or outrage in the community. Well, if that's not the campus trends, fire. If that's not the shooting in Sheraton, sir, I don't know what is. Whether the shock or outrage of the community might lead to public disorder if the defendant is released. The judge now has to address his mind. Is the public outrage, it now has to put itself in the mind of the public. Is the public outrage so much that people may actually revolt against this? It considers whether the safety of the defendant might be jeopardized by the defendant's release if somebody can extract vengeance against him. Whether the sense of peace and security among members of the public will be undermined or jeopardized by the release of the defendant. Is this somebody that the public of Barbados feel, if this person gets back out, I might be in danger? The court has to consider that now. It has to consider whether the release of the defendant will undermine or jeopardize the public confidence in the criminal justice system. If the crime is so heinous, is so bad that we all said, oh my God, not here in little Barbados. The judge now has to apply himself, apply his mind. Is this something that I can overlook in granting this person bail? Sir, any other factor which in the opinion of the court should be taken into account. Sir, the court also now has to give written reasons for its decision. So it's not just that criteria exists. It's not just, sir, that the application of criteria is spelled out, but the judge now has to put it down in writing. The judge has to write it knowing that his or her decision is reviewable by the Court of Appeal all the way up to the CCJ. They have to show that they considered all of these in making a decision whether or not to grant the bill. If they grant the bill where these circumstances exist, they must be prepared to explain to a court above or to the people of Barbados what possessed you, the judge, to give this person bail when nobody else in Barbados can see it. And I hear the noise that I'm not supposed to hear and talking about more hard work, more hard work, more hard work. There is no such thing as too much hard work to protect the people of Barbados and our institutions. If the honourable member, sir, was not averse to hard work, he might, sir, have chosen to pick up this beforehand and read it. He might, sir, have chosen to accept the invitation of the Honourable Attorney General, which sought to explain. He might, sir, have availed himself of the opportunity to benefit from the explanation of the Honourable Attorney General that neither he nor any of his two opposition senators actually took on. He might, sir, have chosen to educate himself instead of coming in here, sir, to confuse people. The last 20 minutes of the Honourable Leader of Opposition speech was complete fear-mongering. He talked about following people in the supermarket, people having to drive the long way around, right? Being afraid to walk in a car park. It was fear-mongering to the extreme. And yet, when asked to comment on the bill itself, the only thing he would have done was change the word may at the top of section 6 to shall. So when he asks, why is it that I keep coming behind the Honourable Attorney General? I don't come behind the Honourable Attorney General. I come behind the Honourable Leader of the Opposition. Because, sir, nonsense must not be allowed to permeate and gain traction.
Honourable member, please, please. Marshall, get ready.
Hey, so, you know, the closest thing I could call these interventions to mind. So, you know, sometimes when you flush and you watch and it doesn't all go on, you flush again and it keeps coming back up and keep coming back and keep coming back up. To be honest, sir, it is annoying if it wasn't funny. Sir, the Honourable Leader of the Opposition, in trying to justify what he was saying, said he recommends certain things. That this legislation ain't doing it. He recommends a new Offence Against a Person Act, which says degrees of homicide, a new gun court, a new constitution, a new whatever. He then said, this bill needs to be done today. It is important. His words, this bill needs to be done today. The same bill he was saying did not go far enough. The same bill he was saying impinges on the rights and freedoms of person. The same bill he was saying, sir, that should take the responsibility from the judges and put it back in Parliament, which the Court of Appeal, which the CCJ, which everybody has said is contrary to good governance and order. It is almost like the words sound good and you just spit them out without actually stringing them together, sir, to make a cohesive pattern that somebody can follow. So, I feel sorry for him, sir, because, you know, sir, when persons are put in solitary confinement in prison, we tend to put them under suicide watch. Because we know that loneliness is a dangerous thing. It plays on the mind. When you don't know who you could trust, when you have no friends, when the people who are supposed to be behind you are sharpening their knives for you. So it plays on your mind. When you come in this house, sir, and there are 29 intelligent people in here, and you're the other one, sitting by yourself, isolated in a corner, it plays on your mind. When you start looking for friends in here when you ain't got none, it plays on your mind. So I feel sorry for him sometimes, sir. But my sympathy, and I'm a bleeding heart. I'm a bleeding heart, sir. But my sympathy for him cannot allow him to get away with misleading the public, sir, and misquoting to make a point. No, I just actually don't say everything on my mind. I choose to give the ones that are relevant. So sometimes I'll pause and think, which you should try it sometime. Sir, the critical thing here, the thing that the public of Barbados was crying out most for is why. Please explain to me how this person got bail. If we narrow it down, it was please explain, you the court, please explain to me how this person got bail. This new Bail Act requires the court to give its reasons in writing. If we are not satisfied, if the prosecution is not satisfied, if the public of Barbados is not satisfied, sir, then it can be appealed and the correct decision granted. So, we recognize there was an issue. We recognize that the existing legislation did not go far enough. We recognize, sir, that the public of Barbados was feeling very concerned about persons with a criminal history and a criminal record being admitted to bail. We recognize, sir, that persons were losing some faith in the judicial system and the judiciary. And we took steps to clarify that. I would give one more point, sir, that should give the honorable member some comfort. Even in the circumstances where a prosecutor does not object to bail, the court still has to apply itself to the reasons stated. So if I read for the honorable chamber, I'm not even reading or trying to educate the honorable leaders, sir, because there's some people that are beyond salvation. So section 6.9. Sir, where the prosecution does not oppose the granting of bail, the court has the duty imposed by Section 8 to weigh the personal interest of the defendant against the interest of justice. As it stands now, and we know the practice is, if for some reason the prosecution comes in there, and this is to stop, sir, unscrupulous lawyers trying to cut deals with DPPs and prosecutors and going outside of the jurisdiction of the court to try to make arrangements beforehand. I mean, I didn't know anybody would actually stand up on record and say that they were party to that, but let's go with it. Sir, even in the circumstance, sir, where the prosecution says, I don't object to bail, the judge still has a duty to put himself in the shoes of the public and decide, is this somebody that should actually get bail? Is this something that we can explain and justify to right-thinking members of society to help them feel comfortable in their beds that justice was served and the interests of all were balanced in this? Sir, I don't want to go through, a lot of it, sir, are the regular things that came up. The specific interventions and applications from the South African legislation, sir, were to correct that part that I referred to before. And just for the benefit of the member, this is not apartheid legislation. This is not legislation passed to downtrod or keep down a specific class of person. This, sir, is legislation meant to ensure justice and deal with a particular situation. As he knows, as we all know, sir, law is about precedent. There is no need, sir, to reinvent the wheel. Anytime you're doing a case in court, so you look to try to find it, has a similar point been made before?
On a point of order, sir, would the honourable member, if he refers to the South African legislation, would he want to give the ear?
Sir, that's not a point. Honourable, there's
Thank
not
you
a point
very
of
much.
order. It's not a point of order.
He could
Honourable.
give the ear. Give the ear, son. Give the ear. Satisfy the public.
Mr. Speaker. I don't have to laugh with him or laugh at him or to actually shed a tear for him, but sir, this is as serious as it gets. This is as serious as it gets. We know, sir, we know in doing a case, in preparing a case, and the same applies to legislation, you look for somewhere where it has been done before. What was the decision? What were the arguments to and from, right? For or against? What can I extract from this that may help me? When we look at legislation, sir, unless it is something peculiar to us and it hasn't been dealt with before, we look for examples, sir, outside. And we adapt the legislation to suit our personal circumstances. Sir, in looking and considering a number of pieces of legislation, this is the one that found favor. This is the one, sir, that most found favor for us.
Honourable, ignore. Soon for now, he will place some. Honourable, soon for now, if he continues, he will place somewhere else outside of this room, so you wouldn't have to hear him at all.
Sir, it is not even.
Hold on. But honourable member, I will exercise my discretion. I am vested with the discretion that the court is vested with. So you can't tell me St. Thomas and St. Lucie. I have that discretion, sole discretion.
Sir, my difficulty, sir, is that with all the fear-mongering, the point is I'm looking at you and addressing you respectfully, sir, as I'm supposed to do. But out of the corner of my eye, I'm seeing gesticulations. I don't know whether, sir, he's getting a seizure. I don't know whether he's getting a panic attack. I don't know if he's about to jump across here, sir, and do something strange. So that's why I keep getting, I just have to look and verify that he's still where he's supposed to be and restrained. But sir, we are comfortable. We are comfortable, sir, that the situation occasioned by the striking down by Justice Griffith of the existing conditions that required somebody to be held for 2 years, 24 months before being considered for bail. That yes, the Court of Appeal is supposed to give us a decision. There's a decision pending from the Court of Appeal. But this is effectively made moot that point. There's really no reason for them to give a decision now, because the government has taken steps to deal with that some other way. And just for the further advice of the Honourable, but at some point in time, it is the nature of legislation, especially legislation relating to criminal justice. It is the nature of legislation that somebody's going to apply, because it is going to impact on somebody's liberty, and somebody is going to appeal the decision. When that decision is appealed, a court must be able to know that if it even looks like if it is offending any part of the Constitution, that this was not passed by a simple majority. This was passed by a majority in Parliament, the same majority that would be required to change the Constitution if we were trying to change the Constitution. So this is paying it forward. This is saying to all and sundry, we are taking this so seriously. We are so vested in this. We accept it touches and concerns the rights of individuals. We do not believe it conflicts with the Constitution. But in the event that it does, the majority passed in here was sufficient if it actually was supposed to change the Constitution or override the Constitution to give it that teeth. That's the simple.
No. You go out. You're wrong, but go out.
As I tell you, sir, I got to keep watching. I don't know what's going to happen next. So having taken all of that into consideration, sir, and I being one of the people who has actually looked at some of the decisions in the granting of bail to say, how did you ever get...
What's the point of order, Honourable Member?
Is the Honourable Member telling this Parliament that... All right. I wanted to correct him. I wanted to correct him. Leave him. Leave him and the Attorney General who he's advising.
Continue, Honourable Member.
I remember when I came on my first day here, I was given a nice little book that had the standing orders of the House, explain what the points of order were, how to raise and do them. I read it back to front, which is why you can get them object sometimes to the Honourable Leader. I'm not speaking to anybody, sir, but I do believe that we probably all should just read it again and just make ourselves familiar. Because what goes on here is televised, and I would like to portray Parliament in a good light. As I was saying, sir, myself being one of those people, and I'm a lawyer, myself being one of those people who said, I cannot believe this person got bail. Myself being one of those people who has said in the commission of offences, that person should never get bail in Barbados. Myself being one of the people to whom the public comes, and they come to all of us to say, what are you all doing? What's the court doing in granting bail to these people? They're coming out and they're committing the same offense over and over and over. You all need to do something. Well, sir, we did it in this piece of legislation. We did it in this piece of legislation. And I am convinced that this is the best that we can do in these circumstances. I also want to commend the drafters. I want to commend the Honourable Attorney General. I want to commend him, sir, because it was no mean feat to get this here in the time that we did it. We had to sideline a number of things. We had to give priority in the drafting to this piece of legislation. And for us to get this to deal with a situation that is current in Barbados, a situation that begs to be dealt with, a situation that the Honourable Leader of the Opposition has begged us to deal with, a situation that we of our own know we must deal with. And sir, I am happy to support this bail legislation in providing a solution and forcing the courts to make the right decisions with respect to bail for accused, decisions that serve the interests of Barbados and promote faith in our criminal justice system, promote faith in our judiciary, sir, and give us comfort when we sleep in our beds at night that the best that could be done was indeed done. I thank you, sir.
Honourable Leader, Government Business.
Thank you, Mr. Speaker. I beg to move the suspension of the House until 3:30 p.m.
Made a second.
The question is that this Honourable Chairman be suspended until 3:30 p.m. All those honourable members in favour, please say aye. Those against, please say no. We think the ayes have it. This Honourable Chairman stands suspended until 3:30 p.m.